Welcome to Witch Draft. This is Jason Mark Anderman. I'm going to tell you a bit about today regarding the mutual non-disclosure agreement, so you can get a sense of what confidentiality agreements usually consist of and what people negotiate. The first thing that you're going to think really hard about with a confidentiality agreement is the business purpose right here. So what's the reason why you're going to be talking? And you want to put that in your agreement. In this particular example, the whole point is to have a discussion regarding a potential consulting project. And that's why confidential information is going to be shared between the parties. Another thing that you want to make sure you really get into the nitty-gritty on is figuring out when people share confidential information, what's going to be confidential and what's not going to be confidential. So first and foremost, you're going to think a lot about, are we going to say that we're going to mark everything as confidential? And if you're going to do a marking requirement, that basically means that the party who's sharing their confidential information is going to stamp it with a legend or a stamp that says, hey, this information is mine, it is confidential to my company, and it cannot be publicly disclosed. That allows the other party who receives it, called obviously the receiving party, to be on guard and know what is confidential and what isn't. If, however, you're going to let somebody come onto your premises or have wide-ranging access to your office and documents, you're probably not going to be able to do a marking requirement effectively because it would take you too long to stamp everything. In that case, you probably don't want to mark everything and just say, everything I have, all confidential information of the disclosing party will remain exclusive property of the disclosing party. And that way you don't have to worry about marking. The next thing you'll think a lot about is exclusions. Exclusions just is a way of saying, hey, what information is not confidential? What just isn't covered? And you really want to do this for two reasons. Number one, just to be fair, so that people aren't shocked by something that they wouldn't have thought is confidential suddenly being confidential. And by setting expectations properly, you really establish a nice basis of trust in the contracting relationship. Number two, you really won't get away with it in court if you end up in a litigation dispute over a confidentiality breach if you try and insist on information that's already out there in the public domain that everybody knows about, for instance, is your confidential information. Believe it or not, it sounds weird, but companies will do that on a regular basis. So you want to make sure that you're very fair here, and that way your agreement is much more likely to stand up to scrutiny later if you get into it with a judge, or more likely, you're just going to have a debate between your lawyer and their lawyer, and you want to make sure that their lawyer is convinced that this agreement really is up to par. So typical exclusions are, as I mentioned, public domain, where basically if the information is already out there in the public and people already know it and it wasn't released to the public by the party you gave it to, then no dice, it's not confidential information. Another thing would be independently developed. So if the party you give the confidential information to, if they have another employee who's never seen your confidential information, never even heard of your company or the business dealings that their employer had with you, and independently developed something that was similar to or like your confidential information, particularly usually this is like formulas, trade secrets, things of that nature, and they can prove it through written records created in the normal course of business, then hey, that's okay. That's not confidential information. And the other would be third-party source, where they rightfully receive something similar to yours from a third party. Mainly, you focus in on your duties with the confidentiality agreement. So basically, you want to say, hey, you're not going to disclose it to anyone else, non-disclosure. You're going to make sure you use it just for the purposes, the business purpose that we mandated here. And you're not going to share it with every employee you have. It's just going to be more on a need-to-know basis. You'll advise all of your employees to say, hey, you need to respect this non-disclosure obligation. And if they need to disclose anything you give to them to their agents and subcontractors, such as their attorneys or their accountants or temp staffing who help them out, you want to make sure that they really are on the ball with making those people sign up to the non-disclosure obligation. You want to get notice as soon as there's a breach, and you want to get all the confidential information returned when the deal is over. Lastly, you want to make sure that if the government or any legal entity requires them to disclose your confidential information in court, you want to get notice ahead of time so you can apply to have it protected. That's confidentiality agreements in a nutshell. Hope that's helpful to you, and have fun using Witchdraft.